So let's get into this absolutely wild legal showdown from 1995. It's a story where, believe it or not, a ghost from the past was called up to try and stop a modern nuclear power in its tracks. We're talking about a hidden loophole, a frantic race against time, and a question that really gets to the heart of what international law is all about.
Okay, so picture the scene. It's June 13th, 1995. The president of France drops a bombshell announcement. He says France is going to conduct one last series of 8 nuclear weapons tests down in the South Pacific starting that September. Now, for all the countries in that region, this was, well, it was a huge deal and seriously alarming news.
The world was watching, right? But New Zealand, they decided to do more than just watch. They decided to fight back. And their weapon of choice? Something nobody saw coming. A court ruling from the International Court of Justice that was more than 20 years old. The big question was, could a dusty old legal decision actually stop a nuclear test? And New Zealand moved like lightning fast. On August 21st, 1995, they didn't file a whole new lawsuit. No, they did something way more specific. They filed what's called a request for an examination of the situation. The goal here was to literally reopen their old case from the 1970s.
Their entire strategy, everything, was riding on one single, kind of obscure clause from that original 1974 ruling. You could almost think of it as a legal time bomb, just sitting there for 20 years, waiting for someone to light the fuse. And it was known by a very simple name, Paragraph 63.
So to really get what's happening here, we need a quick backstory. Back in 1973, New Zealand originally took France to court because they were doing nuclear tests in the atmosphere. That case ended in '74 when France basically promised, okay, we'll stop testing in the atmosphere. But, and this is the key part, the court tucked this special clause into the judgment. Fast forward 21 years, France announces new underground tests, and boom, New Zealand immediately says, hey, remember that clause?
You see, this wasn't some normal appeal. Paragraph 63 was a totally unique reopener clause that the court itself had created. It said that if the fundamental basis of that 1974 decision was ever affected, New Zealand had the right to come back to the court and ask them to take another look at the whole thing. It was a really clever legal backdoor.
So the whole thing was going to come down to one very specific legal argument. What exactly was the basis of that original ruling from 1974? Was it about stopping tests up in the air? Or was it about stopping nuclear contamination, period?
The court decided to zoom in on this one question first. Before they'd even talk about the environment or radiation, they had to figure this out. Did New Zealand even have the right to use this Paragraph 63 loophole for underground tests? It's basically the legal version of a bouncer at a club asking, are you even on the list before you can get inside? The whole case depended on the answer.
In this chart right here, this gets to the absolute heart of it. New Zealand's argument was, look, the original case was about preventing any radioactive contamination. Simple. But the court went back, they dug through all the old files from 1973, and they came to a very different conclusion. They decided that the original fight was laser-focused on one single thing, radioactive fallout from tests happening up in the atmosphere.
Okay, so with the whole fight narrowed down to that one tiny point of law, the court was ready to make its final decision.
And the verdict was in. The court ruled that the basis of the 1974 case was only about France's promise to stop testing in the air. So because the new tests were happening underground, the court said that original basis wasn't affected. That meant the conditions to use Paragraph 63 just weren't met. The case was dismissed on procedural grounds, which is a fancy way of saying it was thrown out on a technicality before they even got to the main arguments about safety and contamination.
And the decision wasn't even close. The court dismissed New Zealand's request with a vote of 12-3. And since their case was out, so were all the applications from other countries trying to join in, like Australia, Samoa, and the Solomon Islands. Just like that, from a legal standpoint, the path was clear for France to go ahead with the tests.
But hold on, the story isn't over. Because those 3 judges who voted no, they wrote some incredibly powerful dissenting opinions. They basically argued that the majority was being way too rigid, sticking to the literal, black-and-white text of an old ruling instead of adapting to a new reality. They said the majority was choosing the letter of the law over its spirit.
Judge Wiramantri's dissent just cut right through all the legal jargon. He said, look, the reason we're here is the same. French nuclear tests in the Pacific. The potential damage is the same, radioactive contamination. The only thing that's different is where the bomb goes off, in the air or under the ground. For him, getting hung up on that distinction was missing the entire point.
Yeah, the dissenting judges felt the court had missed this huge opportunity. They said, hey, international environmental law has grown up a lot since 1974. They pointed to big ideas like the precautionary principle, which basically says if an action could cause serious harm, the burden of proof is on the one doing it to show it's safe, not on everyone else to prove it's dangerous.
And this really brings us to the core question that this whole case leaves behind, a question that's still being debated in international law today.
New Zealand's own appointed judge, Sir Geoffrey Palmer, he put it so simply. He said both kinds of tests, atmospheric and underground, are about nuclear contamination. And for him, that shared risk was more than enough reason for the court to say, okay, let's examine the situation. He thought they should have moved on to the next stage of the case.
What's really fascinating, though, is that even as the majority dismissed the case, they stuck this one line in their decision. They said their ruling didn't change the basic duty of all countries, including France, to protect the environment. It was this little nod, almost like they were saying, okay, you lose on this technicality, but we hear you on the bigger environmental point.
At the end of the day, this incredible case is about so much more than a legal loophole. It perfectly captures that tension between one country's right to act and the whole world's shared responsibility to protect our planet. And it leaves us with this huge question to think about. When our scientific understanding of a threat changes, should the law be flexible enough to change with it? Or is it stuck, bound forever by the exact words written down decades ago?